And finally, a couple final tips. Make sure that you're working with your web designer on this. Pinterest has been a up-and-comer in the social media world, and there's been a lot of controversy over copyrights when people are pinning pictures or logos and things like that from websites to their Pinterest page. So there's actually a lot that you can do in terms of website programming to prohibit people from lifting pictures, whether it's for Pinterest or from Facebook or anything like that. So as I said, work with your web programmer, because they can set it up so that you get an error box like this that will prohibit people from taking your images and taking your content. Yes?
Are there any protections against, a competitor, I put it in like Google AdWords, my company's name?
Mm-hmm. Actually, I just had a situation like that. I had a client who found out that one of his competitors had registered his own company name as a Google AdWord. And there are a couple options. There's the straightforward trademark infringement, but actually I think the easiest way to go is contact Google. It's a violation of the terms of service to use someone else's trademarks for your own AdWords. So I would start with either contacting Google directly to say, hey, this person is violating my rights by using my trademark as their AdWord, or you can contact the other party directly and say, this is my trademark, you're actually violating a law and violating the terms of service by doing this. Please cancel, the AdWord. So those are two things you can do, and if those don't work, you can be more aggressive with a court action.
How do you know definitively that they've got your name registered as a Google AdWord?
Well, the first step is, I would Google the things that you're concerned with, and if it takes people directly, the first thing on the list is your competitor, there's a good chance that they have an AdWord. The other thing you can do is contact Google and try to purchase the AdWord for yourself, and they should be able to tell you that, oh, someone else has claimed that already.
What about, we had a postcard campaign and then put things on our website that were kind of cute and clever. We purchased photographs
Mm-hmm.
and had some advertising. We were contacted by somebody who said, we really love what you're doing. Would you mind if we copied your ads? And I said, I would. We've spent $100,000 developing our kind of brand. So I found out later that the same photograph was used, and that's okay. I mean, we purchased the use of the photograph, but others can use it. But literally, they took our text as well and simply changed our company name and dumped in their company name.
Mm-hmm.
Now, our company name is trademarked.
Okay.
Is the words that we paid somebody to write, are those also trademarked?
Those would not be trademarked, but they would be subject to copyright protection, because there were creative elements that went into writing the rest of the text, designing the layout, selecting the picture. You put it together in a whole package of an advertisement, and so that is able to, or it's subject to copyright protection. So you could contact that person with a nasty cease and desist letter saying, thanks for contacting us, but you violated what I told you, and we demand, you're infringing on our copyright rights. We demand that you cease all use of this advertisement. That's at most what you can get if you pursue this beyond the cease and desist letter would be a court order making them stop. If you go through a registration process for future advertisements, you can also get attorney's fees, sometimes lost profits, and again, destruction of the infringing advertising materials. One thing I want to add, following up on the AdWords question, there is also protection regarding domain names if you have a registered trademark. So there are a lot of situations where companies will register domain names that are one letter off from their competitors, hoping that they will get all of the hits to their website for the people that mistype a web address. There's actually a domain protection out there for people who have registered trademarks, that they have priority rights to a domain that contains their exact trademark, but then also they have a little bit more protection for domains that are deceptively similar, is the terminology, to their actual trademark names. So if you're having an issue with that, that's another another thing to consider as an advantage to a trademark registration. Yes?
In your opinion, why is it desirable to prevent people from pinning? Because from an advertising point of view, wouldn't you want people to spread your product and have, if it's on Pinterest, have the pins lead back to your website?
That's exactly correct. I don't flat out tell people to not allow pinning, because in some industries it is highly advantageous to allow people to pin their photographs to help get the word out. It's just something that you should make a conscious decision about. If you want to allow people to take the photographs or take images from your website and pin them to your boards, go for it. There's definitely I think I mentioned earlier, I work with a lot of photographers, coincidentally, and they fall in two very distinct camps. Some of them want people to pin their images all over the place. They want them to share them on Facebook to help get word out about their company. Others charge their clients a really high price to buy the rights to the photographs. And in those situations, they basically have sold the copyrights to their clients. And so then they don't want to allow pinning from their website because it would violate their clients' copyright interests. So it really depends on whether you want people to pin them all over the place and get the word out, or whether you view what is on your website as being proprietary that you want to protect. Yes?
How does that affect the release that you had signed?
I would work it into the release and say, it really depends, again, what your interests are. Sometimes people flat out prohibit any use of their materials on social media 100%. Others say, go ahead and use this yourself on social media, your blog, whatever. Just always give credit to me or link it back to my website so that people know where to go to get the services. But a well-written release will say what rights people are releasing to you, and that will define a scope for how you can use their image. It will say, I just want it on your main website, or it will say you can use it anywhere. Again, to use the photographers, for example, sometimes people say they just want it used on Facebook and nothing else. Other times the photographers will say, by signing or by hiring me to take your wedding photos, you're allowing me to use them on my blog, my social media accounts, maybe submit them to wedding magazines as a feature item, which a lot of couples don't think about, their pictures appearing in a magazine later. So it really just depends on the wording you use in your release, where you can use the pictures. We're going to move on from marketing purposes and start talking a little bit about social media and employees. I would say that the most often I see employee questions would be people who are hiring a new employee. They want to know what they can do online to check into a person's background. If you're a fan of The Office, I found this and it kind of made me laugh, but basically Michael is asking if he can be your friend on Facebook. So right here it's good for a chuckle, but if you are actually a boss and you're contemplating friending your employees on Facebook, I would think twice, because not only will you be able to see all the things that they're doing in their free time, but they'll be able to see what you're doing. It's a two-way street, so think about it before you friend people that you work with. I wanted to take a minute and talk a little bit about an innovative hiring program. Whereas more and more employers are using social media and LinkedIn to screen their job applicants, there are actually some companies who are using social media for the actual application process. And I want to tell you a little bit about the Lucky 13 program. This is a program offered by Campbell Mithun. It's an advertising agency here in town, and they run the Lucky 13 program to hire their summer interns every year. It is a Twitter-based program where potential job applicants, they sign up on a website saying that they're going to participate in the program. And then there's a defined period of time, usually in late February, where the job applicants are supposed to make 13 tweets about why they would be a good candidate for the job. They're supposed to showcase their creativity. And the way that the company tracks the tweets is you're supposed to use a designated hashtag. And so the company will track these tweets, they will interact with the people, and then at the end of the the window for making these tweets. They'll compile them all together, they'll categorize them per applicant, and they'll take a look and see, who has a lot of creativity. They narrow it down, and they end up doing Skype interviews with the final candidates. So it's a completely internet-based hiring process. It's appropriate for them being an advertising agency where creativity is important, but I have to mention it also was very expensive. They ended up hiring, I can't remember how many people, just to interact with all of the job applicants. So it can be expensive, but it is an appropriate approach for their company. If you were planning to use social media to screen your job applicants, I would recommend avoiding any sort of fraud or misrepresentation. I'm sure that seems really obvious to you. But there have been situations where people have created a false Facebook account to try to friend people in order to see what they have on their Facebook pages. Obviously, any sort of fraud or misrepresentation as to who you are and why you're trying to friend them is illegal. Not only does it violate state and federal law, but it also violates the terms of service for all of the social media sites. That's kind of an extreme case. It seems really obvious. There was also a situation where somebody claimed to be a member of an alumni association in order to friend someone on Facebook to network for job-seeking purposes. That person was also found to be violating the terms of service because they were being untruthful as to their qualifications. So even the little minor exaggerations that you might find on a resume should not be translated into any sort of misrepresentation on a social media account. We're going to move on because I think that seems obvious. Yeah.
How does that apply, for instance, to a Facebook business page? If Facebook allows an individual to create an account, and then you can create a business page. Now, who owns that business page? The business you're creating it for, or the individual working for the company?
That's actually something we're going to talk about too. It's something that needs to be clearly defined anytime you're asking an employee to do any sort of social media for you. You need to define who's going to own the account, and then who is going to have rights to maintain that account and take anybody who's following that account after separation between the company and the employee.
But you could not create a imagined company persona and create that profile on Facebook and then a business account. You need to have an actual person.
That's correct. Mm-hmm. And I would just make sure that the person who's creating that account is a high level. If you don't have it documented, that the employee is doing this on behalf of the company, then I would just make sure that the person who is listed as the creator and the administrator of the Facebook page for the company is someone who's going to be with the company a long time, or who is an owner of the company. That helps reduce some questions later. Right now, we've been hearing a lot about the password controversy. There have been a lot of stories in the news about employers demanding that job applicants give up the passwords to their Facebook page so that employers can get in there and see all of the things that people have on their Facebook pages. Like I said, it really made the news, so there have been a lot of people voicing their opinions on this. And there are competing interests. Employers really want to know what their employees are like before they hire them. The potential employees are claiming that this is their private information. They have the right to protect who sees what on their Facebook pages and things like that. So really the issue comes down to, does a person who puts material out on a social media site, do they have a right to privacy in that in that material that an employer would be violating by demanding to see it? And of course there hasn't been a ruling on that by a court of law or anything, but politicians have really gotten into the fray. And recently there were 2 bills that were introduced at the federal level to address this very issue because a lot of people were taken aback by it. The first bill was the Social Networking Online Protection Act, known as SNOPA. That was introduced 2 weeks ago. And then last week another bill was introduced called the Password Protection Act. And these are very similar, but they do have different levels of protection. SNOPA is designed to protect employers and universities. It also applies to students. But it's designed to prohibit employers and universities from demanding release of passwords for any sort of social media account. The Password Protection Act is very similar, but it does not protect students in universities. But it does have a little bit broader protection in that it goes beyond the social media accounts and covers any sort of electronic information that an employee might put onto their computer at work or a work-provided cell phone that is not used for work purposes, or that isn't put on those devices for work purposes. So if you have a person who's using their personal Facebook page at work, the Password Protection Act would keep an employer from trying to get in and see that information. These are very new bills, obviously. I can't predict how they're going to be tweaked and changed before one of them is adopted, but just be aware that there is legislation that has been presented to try to address this issue. I actually think that it doesn't make sense to demand a password from a potential job applicant, because if an employee has materials on their Facebook page that you as an employer can't see, your customers and your vendors and your other professional relationships aren't going to be able to see it anyway. And there's also a school of thought that says once you see that information from an employer or for an employee, are you legally obligated to do anything with it? Like if you demand a password, you get into an employee's account and find out that they have inappropriate pictures that might violate the law, or see that they say something in one of their posts that they broke a law, would you then be obligated to notify someone that you've seen it? So there are some additional legal risks to demanding those passwords. So as a general rule, I would avoid demanding a password. Now, let's say that you've posted a new job position, you've gotten a stack of online applications and resumes, and you start going out onto Facebook to look at these applicants. What do you do if you see a picture like this? It's not a very professional looking photograph. Some would say that the bottle is perhaps a 40-ounce bottle of beer. But in general, the person just is not looking like a professional presentation of themselves. Can you use this picture as a reason not to hire them? And the answer is no. There is a Minnesota statute that protects people who are lawfully consuming products. It applies to alcohol, prescription medications, foods, cigarettes, things like that. Anything that you are lawfully consuming that might be displayed in a photograph on any of your social media accounts, you cannot discriminate against either your current employees or your potential employees on the basis of them doing legal things outside of the workplace. Now, if they post pictures of themselves drinking on the job or on your work site, maybe after hours, they stick around and have a drink after work, that's a totally different situation. Then they are basically violating, presumably, your rules for being on the job and rules of what are allowable at the workplace. So then that can be grounds for discipline or termination. Probably the most obvious thing when you're looking at people's social media accounts, you need to be aware of discrimination. You need to make sure that you are not using anything that you find on a social media site to discriminate against job applicants. And actually, to take it one step further, you need to make sure that you're using your social media screening procedures uniformly. So you can't be discriminatory in who you're checking out online. So for example, you couldn't look up Facebook pages only for women or only people of a certain ethnic origin, because that is deemed to be a discriminatory hiring practice. Discrimination is protected at both the state and the federal level. I think you guys as employers probably know that already. But you need to make sure that you are, as I said, using your screening procedures uniformly. We're going to review what the protected classifications are, because unfortunately a Facebook profile is like a running list of all the protected things that you should not use when you're hiring someone. So this actually is it's a screen cap of a Facebook profile. This is all information I was able to see on his profile, and we are not friends. So this is all information that he made available to basically anybody who is out there looking up his profile. I blurred out his name just in case you'd be unhappy with me using him as an example. But here we can see what languages he knows, which could be an inference, or you could draw an inference from that as to their national origin or ethnicity. It gives his birth date, including year, so you can judge his age. It identifies his education. That's pretty normal. But as we keep scrolling down the profile, he has a lot of other opportunities where he can reveal some of these things to you that you could use to discriminate against him. Those include his religious views. He's made a joke of it and say that he believes in quantum physics. But I have seen a lot of other people who actually state their religious preferences here on their profile. There's a place to designate political preferences. That's not a protected classification, but I suppose it could sway you a little bit in who you hire. And down here at the bottom, sports activities. Christopher indicates that drinking is one of his sports. So again, that's probably something as a potential employer you don't want to see on your employees' Facebook pages. But as we discussed, if he is legally of age, he's allowed to drink outside of work. So you can't discriminate him based on his drinking, sporting preferences. And finally, continuing on to the bottom of the Facebook profile, we see his sexual preferences. He's interested in women. We see his relationship status. He's single. We already knew his gender, but he states it here. And then I had to jump over to a female's profile to give an example of another one that I actually see this all the time. And I don't know if it's just that I have a lot of friends of that age, but a lot of women, it seems to be the trend that if they are pregnant, they want to announce it on Facebook by posting a sonogram image. And pregnancy is an example of something that you can't discriminate against employees or job applicants on. So to review, the protected classifications that you should watch out for are race, color, creed, religion, national origin, sex, sexual preferences, your marital status, age, disability. About the only one that I think you can't glean from a social media profile is the last one, and that's the status with regard to public assistance. Nobody is announcing that on their social media accounts. So tips for screening employees. Just don't ask for employees' passwords. One thing that I have heard people recommend that you could do, you run into some of the same issues, but you could ask an employee in a job interview to walk you through their social media profiles. You can't discriminate against them if they refuse, but that's one way that they can show you what they're doing online. That's probably most appropriate for a social media related job where social media is going to be a key component of the job, or if you are going to be asking them to use social media to maintain some of their sales relationships with vendors and things like that. As we've already talked about, don't set up any fake or inaccurate profiles. Apply your screening procedures uniformly. And one thing that I've heard of one company doing is they actually, they did an initial review of all the job applicants. They weeded it down to like the top 10 or something like that. Then they had someone who is not going to be the hiring manager go through and do the social media screening, just to see, if were there any legal violations, or does the person generally present themselves professionally, things like that. And then that person could report back and say, I didn't see anything that was inappropriate, or again, that person also needs to make sure that they are not violating the law. But it's another way to insulate yourselves as the business owners from any claims of discriminatory hiring practices. But that being said, you might have to follow them to be able to even monitor what they're doing. So I see we're at time. I had one last point I was going to cover regarding your employees and how you can minimize your liability for what they're doing. I'm going to cover it in about 5 minutes if you can stay that long. This is one of my friends on Facebook, so I blacked out her name, but she posted this one day saying, "My boss is the coolest guy in the world." And then the next minute she says, "This is what happens when your idiot boss sees your Facebook page up at work." So she was on Facebook at work. Either he saw it and posted the first line, and she came back and posted the response, or she realized he was looking over her shoulder and posted the first line that he's the coolest boss. Either way, if your employee's on Facebook at work, it can not be a good thing. And if she's posting negative things about the workplace, that can also damage your reputation. So you want to make sure that your employees are not doing things like that. Now, you had asked a question earlier about ownership of a social media account. There actually has been a lawsuit about that. It's called Marymount versus the Susan Fredman Design Group. So let me introduce you to Jill Marymount. She was working for an interior design firm in Chicago, the Susan Fredman Design Group. And this is her Twitter account. There we go. And we'll see, these are tweets from September of 2009. And you'll see on the 15th of September, she's been tweeting about a new article posted about the organization and things like that. And then there's a couple days off, and then on the 21st of September, she's announcing the newest blog post on their company website. What you cannot tell from this social media or from this listing is that on September 15th, she was hit by a car. And very serious accident. She was actually in a coma for several days and was in the hospital for, I think, a month and then rehab after that. So these tweets after September 15th are not her. What she found out when she kind of came to and had her medication reduced is that someone from her employer had come to see her at the hospital, had asked her for her passwords, and after that date, they were posting things on her account without any sort of disclosure that it was no longer her. She felt her rights had been violated, so she sued them for right to privacy, misappropriation of her likeness and her image because they were doing it under her name. The court kind of indicated in an initial ruling that it was going to support her, but unfortunately Jill missed a very important hearing, and so the case ended up being dismissed. But a lot of the legal commentary is that what the employer did was wrong. They blatantly withheld themselves as being her personally, but there are a lot of things that you can do to address this issue. First of all, when you're hiring employees, if you expect them to either post on an account in the employer's name or use their own social media accounts for business purposes, specify it in the employment contract. Say, this account is going to belong to the employer. This account that we set up to use for you to use for business purposes is going to remain the property of the employer after the termination of the employee relationship. That's all I had today. Thanks for sticking around a couple extra minutes. Were there any additional questions? I will be hanging around too if anybody wants to come up and talk with me privately. But thank you for coming.